Hi, Don McLaughlin from Falcon Discovery here at Legal Tech 2013. I'm pleased to introduce Phil Favro from Symantec. Phil, great to have you. If you'd give us a little bit of your role at Symantec currently.
So I'm Discovery Counsel for Symantec, and I have a chance to speak and to blog and write about some of the key discovery issues that are impacting companies who are here, legal counsel, and the judiciary, as well as academics as well.
And what's your experience prior to joining Symantec? I know you're a lawyer. How, as a practicing lawyer, did you encounter e-discovery? And then I'd like to ask you a little bit about how that experience is shaping the work you're doing currently with Symantec.
So I worked as a business litigation attorney for 11 years before coming onto Symantec, both on the defense side at a medium-sized firm, and as well on the plaintiff side on my prior practice after that. So had a chance in each of these to really get involved deeply with e-discovery. Not voluntarily, I might add, but like many people, we had to learn on the fly, and then it became a love of mine because it was something that our clients really needed to understand and take care of.
Interesting. So you saw it in a real personal way in your practice the demands created by electronic discovery generally, but then the direct impact it had on your clients.
Absolutely. The direct impact was a significant bill, and getting hit with a production order requiring our client to produce every document relating to revenue over a period of several years, and having to actually cull data nearly a decade ago from 5 different continents where offices were located. That taught me the ins and outs of e-discovery, and that we did not want to be on the backside of that ever again.
Got it. So, obviously the digital age and technology has been the source of so many of these challenges in the legal field. How do you see technology helping address those challenges for the legal field in particular? And what do you see going on in Symantec that is directly addressing those challenges?
Well, so with respect to technology in general, technology is a way to make discovery more proportional. And that is one of the huge vehicles that we're seeing being driven to try and control these costs and burdens associated with e-discovery. They're astronomical, and they keep spiraling upward. And how do you get a hold of it? Well, you've got to have the right process. You've got to have great advocacy from your outside counsel. But on the inside, you've got to be able to take care of your e-discovery house, both before litigation and during. And technology is not a cure-all, but it is one of the ways that it can possibly address these issues in a more reasoned and efficient and effective manner, and I would strongly suggest in a more proportional manner, which is what courts are requiring.
And so from your litigation experience representing clients, most of whom I would assume are companies, do you see the tools that Symantec has being of benefit to the clients that you previously served, that if they had that capability internally, they would be that much better prepared when an electronic discovery case arises?
Absolutely. I don't know how many times I've thought, if I'd only had Symantec Enterprise Vault, if I'd only had Clearwell, and I mean there are many other good products in the market, if I'd only had the right technology at my fingertips, I could have been able to serve my clients that much better. Now, of course, it was before a lot of these products were on the market too, let's be honest. But how I could do it better, there's no doubt about it. I feel like, gosh, having today's technology would have made all the difference in the world.
And likewise for your client, if your client had had that technology internally, would they have been that much better prepared?
It's speculative, but I would assume the answer is yes.
Okay. So you touched on proportionality, and I know that you moderated a panel on proportionality with Judge Moss, Sean Cheadle, and Ariana Tadler yesterday. And I know that you co-authored a recent a law review article that is in the Michigan State Law Review. If you would tell me a little bit about the genesis of that law review article, its title, etc.
Well, thank you very much. Yeah, so the article is entitled New Utah Rule 26, a blueprint for proportionality under the Federal Rules of Civil Procedure. It's a mouthful, right? We're lawyers. We always deal with mouthfuls, right? But the bottom line is with the article is that it advocates amending the Federal Rules of Civil Procedure in a very modest way so that we can better emphasize the proportionality standards that are now extant in the federal rules so that judges and lawyers and clients better engage in proportional practices. And I co-authored the article with a judge from Utah, Derek Pullen. He was instrumental in amending Utah's laws and making sure that proportionality was the touchstone of their discovery practice. We need to have that here in the federal space as well. The fact is, it should be there. It's been extant for 30 years, but it's been mostly overlooked. And so my article is a way of trying to drive some of the amendment process. Hopefully we can make it, we can better emphasize the amendment in there, or excuse me, better emphasize the concept of proportionality. And I've given some suggestions on how to do so.
Well, it's interesting. That'll be welcome relief for our corporate client base who operates around the nation, that sort of change at the federal level in terms of an emphasis on proportionality. I know personally from the clients with whom we work that's top of mind for them. And this time last year, we actually had a webinar with in-house lawyers that talked about the need to constantly address proportionality. And I think the in-house lawyer, and I wonder your views on this, serves a unique role in the sense that they are working inside a business that needs to continue to operate. And they, I think, get a more real understanding of the what is reasonable given the value of a case, given the impacts to the business and the business unit in particular. So I guess from your perspective, are you seeking additional advocacy, and do you feel like there's a need for additional advocacy from, say, the corporate sector or outside law firms to add additional support for a change with regard to proportionality?
Absolutely. In particular, in-house counsel needs to insist on better advocacy by retained counsel, by their outside counsel. In-house counsel needs to make sure that their lawyers are engaging in proportional discovery, because if they do, they will reduce the costs, they will get the burdens down, they will only make their job easier. Because what I have found, and what the experience of most judges is that most lawyers and judges still don't know that much about proportionality, even though it's been in the rules for 30 years. And if in-house counsel can get educated on it, they can potentially ensure that this sort of change becomes more widespread and implemented.
Well, I will say from my experience as a former in-house lawyer and also an outside lawyer, what you're advocating is welcome for us in our work, because I think that the more in-house counsel is engaged in that assessment with outside counsel, discovery will go smoother, it'll be more efficient, and it'll reduce cost. And so kudos to you and your cohort for the article, and best of luck with its wider distribution.
Thank you very much.
It's a pleasure talking to you, Phil.
Appreciate the time, Don, and best of luck in your work too.
Thank you.